occasionally you hear these stories about where, upon a death, that a person has left a handwritten note with further instructions regarding their estate. Is that really acceptable in a court of law, since the lawyer may have not had an opportunity to prepare that document, but yet the deceased left a last wish in essence?
Okay, well, you're asking me a bar exam question. It was a long time ago that I took the bar exam, but in New York, you can have a handwritten will, but the will still has to be executed in accordance with the law. So you can handwrite it as long as you sign it. Before you sign it, you state to your witnesses that this is my last will and testament, so you publish it to them. And then you have two witnesses who witness that publishing, your statement that it's your will. They witness your signature, and then they sign as witnesses. So you have to tell them, I want you to be my witness, this is my will, and if it's handwritten, it's perfectly valid. Very often you'll have people who will make separate lists, and sometimes we do it in our wills. You'll have someone who has a sentimental attachment to a lot of personal property, and they may have, you know, dozens of items that they'd like to leave to different family members. And sometimes I'll recommend, especially I had a client once who was calling me up regularly, sometimes twice in 1 year, to change who was getting a secretary. I didn't know what a secretary was at the time, and it wasn't a living human being, it was a piece of furniture. And he would change it around. He had tapestries, he had a secretary, he had this, and he kept changing it. I suggested that he pick a person of trust, leave all of his personal property to that person of trust, and with the notation that I have a side note and I'd like you to distribute it that way. Now, it's not enforceable in a court of law. So if that person of trust turns out not to be so trustworthy, there's nothing that can be done about it. So I wouldn't recommend that for an original Norman Rockwell print, but for a 45-year-old secretary that, you know, is probably not, in this case it wasn't an antique. It really was sentimental value. It had belonged to a grandfather. And he kept switching which niece and nephew he was giving it to, depending on who said hello to him that morning, I guess.